and Holly Wittenberg. Mr. Mazada will discuss his PhD research project in artificial intelligence, law, and cognitive science, which examines mistakes made by AI in contract formation and doctrinal questions these raise in various legal systems. Turn it over to you.
Thank you so much for the introduction. I'll go ahead and share my presentation. So just to give you a quick recap of what we have been doing in my chair, as we call the departments back in Germany. We've been dealing with a couple issues in IT law sphere, and one of the things that we actually came up with was that a lot of research is devoted to the responsibility part of the issue when it comes to artificial intelligence and contracting, and also to the allocation of legal personality or some form of legal personality to the AI. But none of the research was actually based on the fact of mistake and what kind of doctrinal questions does it raise, both in civil and common law spheres, law systems. So we'll dive into the study and see what actually we're going to talk about today. First thing is going to be, first let me say that we have interdisciplinary research here. So we have cognitive science, contract law, and also artificial intelligence. The goal actually is to understand how we as humans make decisions, and particularly contract decisions, and which kind of psychological errors can occur during that process. So we'll then dive into the contract law and figure out how does that relate to the mistakes in the contract formation. And then we will try to draw parallels between human decision-making and AI decision-making, and also identify the errors that disturb the process of AI's decision-making, and finally find out what kind of mistake, operative mistake doctrine do we need in civil or in common law systems. So let's dive into human decision-making. First thing I want to notice, I want you to pay attention to is that we're going to talk about very sci-fi. It might sound like a sci-fi things, but we will try to talk about something, or we will try to give examples of the things that are reachable to a greater audience of people, like non-lawyers or technicians. So first thing first, we will try to see what is the decision-making process of a human, and Professor Herbert Simon actually got a Nobel Prize for classification of, or for giving the chronology of the processes that happen actually during the decision-making. And the first stage of decision-making process, he said, is intelligence, where you gather information about the thing that needs to be regulated or needs to be solved. In this case, it would be a need to purchase some product, and you would be conscious about that fact. The second stage, he calls it design, which is finding out the alternatives, finding out what is important to you, and basically searching for a deal. The third thing would be choice, where you actually go ahead and clarify your choice. You make an emphasis on some decision, and you decide to purchase a specific item in this case, right? So initially, his research said that there are 3 steps of decision-making process, but then later on, when he dived into the cognitive psychology, he said, well, there are some errors that we do apart from those 3 stages. And he said, okay, then there is a fourth stage, which is an implementation stage, basically where you go ahead and take the action, not deciding to take the action. And for law purposes, third and fourth decision or stages are the most important, because the errors or mistakes that happen in those stages are tempted to be regarded as operative as compared to intelligence and design phases, where you as a formant of a will or formant of a declaration of intent in a common law system, you are in the control of what you are looking into, right? You decide if you need to purchase a product. You are looking for a deal. You are limiting the scope or the spectrum of the things that you are looking into. So keeping that in mind, let's see what kind of errors. I'm refraining from using the word mistake because we will have mistaken law. So I would like to focus on the word error when we're talking about the error in the psychological sense, because error encompasses all of the occasions where some sequence of physical or mental activities fail to reach the intended outcome. And James Reason, a famous psychologist, he came up with 3 potential types of human errors in psychological sense. So he said basically we have slips, which are very little potentially observable as externalized, actions not so intended. This can be slip of a tongue when you, instead of Aaron, you say Ashton, or slips of the pen where you would write 50 instead of 55, or a slip of an action where you would press some button that you wouldn't otherwise press, right? These are not that crucial to the outcome, but there are still some mechanical errors happening in your cognitive process. The second type, he says, they are lapses. They are more covert or error forms, which will result either from the failure in the memory or actually from the experiences that person had, and the bad experiences, let's say, right? And it would be not visible to us because the sequence of the actions are so natural that you would think the person actually intended to do that. But it is actually visible to that person that, oh, I made a mistake, right? And the third is mistakes. So the error is a general category which encompasses slips, lapses, and mistakes. So mistakes, they are some serious stuff that goes on, right? You would end up going to a doctor because of them, because there are deficiencies and failures in the judgmental process. Like Alzheimer's patients are 99% of the time making mistakes, not lapses or slips. So you would end up having something grave that would influence the outcome of the intended transaction. So now that we know what kind of stages of decision-making process we have and what kind of errors can happen, let's see what is a mistaken law and how we as lawyers came to say, okay, there should be a doctrine of mistake. Before going into it, let me just put it back. There is this, so we know as far as in Roman law, the mistake was not regarded as something crucial, right? You would go buy a candle holder. You would think it's gold, but it will turn out to be bronze, but you would not be able to return it back because that's what you bargained for. And the psychology behind it is that the law is going to regard only those mistakes as operative, which are potentially observable by an objective third person. So I can't dive into the person's brain and see what actually he intended to purchase. That is why you would say only those mistakes are operative in Roman law that are potentially observable by the third party, I mean the second party, who is the other party to the contract, and could have been brought to the attention of the mistake maker. And the idea is that there are three stages of will formation. That is in German, and in English it would be declaration of intent. So before purchasing some product, you go through three stages of declaration of intent. First would be motivation. That is when you want to conclude a contract, and you form your motivation to do so. Don't read the second part, so let's focus on the classification. The second is term, where you would identify your terms. It can be the model of the phone, or it can be the insurance policy, it can be everything. So the second stage of declaration of intent is formulation of the terms. And the third thing is expression. So you formulated your intent, and you now go and declare it. So that is, the third step is the step which gives the legal weight to your declaration of intent, right? So now let's shift to the second part. And as I said, the law says it should be observable. And the beauty of English language is that when we talk about mistake, the mistakes that people do in term stage or in expression stage, they are very identifiable. You can see that there is a mistake that should be rectified in some way or the other, right? So let's see, there is a term mistake, which means one of the parties have unwillingly misidentified other party or unwillingly misattributed some fact to subject matter. So you would have a jewelry shop seller who would think that the person who is buying diamonds and writes him checkout is a very reputable person, but he wouldn't turn out to be that. And if there was you can go to the fraud issues, duress issues, but what is important is that there was a misidentification. So I mistook his identity to be something that he is not. Or the second thing, you would unwillingly misattribute some fact to the subject matter. So you would think these apples are good for diabetes, but they would turn out not to be good. So you would have misattribute unwillingly some fact to subject matter. Or the expression things, right? You would have a party had unwillingly misspoke, mistyped, misclicked when expressing his will to conclude a contract or his intention to conclude a contract. You would go to Amazon and you would click something that you wouldn't normally click. And there is this buy one tap or one buy option where you would just click and it will just be done. You don't have an option of reviewing what you have purchased, right? Or you would mistype the amount of raw material that you need to buy. If there's a miscalculation error or something. So as you can see, those two are pretty much, just to give, or it's enough of a justice to give the party making the mistake right to avoid his declaration of intent. But let's now focus on the motivational errors. Those are errors, and I'm calling them errors because in English language I couldn't find anything that would make it possible to put a miss and another word which would turn to a verb. So what is a motivational error is party concluded a contract willingly, so I was fully aware of the fact that I want to conclude a contract. But the reason why I wanted to do so turns out later to be erroneous. So I would think that my phone is broken. I would go to Walmart or whatever. I will buy my product. I will come back home and I will see that it was a temporary issue and my phone is back. So I will have no recourse, or I will have no stand in the court of the law to take my new phone back and say, the reason why I bought this phone was erroneous, because why law says that it's not mistaken illegal? So that's because I was the only one who was in the control of this reason to buy a new phone. And there was no cognitive failure in my brain. I was willingly going to buy a new phone, and if my phone would have been dead, I would still hold on to my new phone. That is the ideology why the law says motivational errors, no matter where, are not going to be regarded as operative. The others, given some conditions, of course, are going to be, and you will still need to remunerate the other party for the mistakes that you did. So now let's look briefly into the AI decision-making process. So this is a chart of a deep neural network operating in an environment. Actually, the question can be later on that why I am using deep neural networks to see what is going on in AI's brain, because we can as well use rule-based algorithms where if then and that, but I don't see a future after 5 or 10 years when we have this people who are very enthusiastic about what they are doing to use rule-based systems to conclude contracts. So they would go ahead and try to use some deep neural network which will self-learn and try to define or try to observe the needs of the user to purchase some product. So what would happen is AI would observe the environment, and it will figure out a need of a user for some transaction to be concluded. It will summarize it and put it on a state box that you see over there. And then we will have the modeling stage where there is 5 input layers, and potentially, I didn't want to limit it, there are 4 other output layers. So what happens is there are millions, it can be a lot of the deep layers or hidden layers where the options that AI has refine into becoming some 4 or 3 options, right? And then you would have policy, which is exactly what you preset into the brain of AI, saying that your goal is to satisfy or to buy a budget-friendly whatever for your user. So that is why one of those 4 outcome or output layer options would be voted or would be devoted a numerical value that will take it from being an option to being a decision. And then you would, and then the agent will take an action, return back to the environment, and get a reward for that. So that was observing, modeling the issue, taking action, and getting reward. And getting reward is something unique to the AI. We don't see that often in people's brain. We have satisfaction, okay, right? We do conclude a contract. There is some momentary satisfaction associated with that, but you would still have that satisfaction fading away after some time. You don't have like a numerical satisfaction value that you have all the time in your brain. That's why people keep buying new products, right? After some time, you're just fed up with the product. You don't have that excitement anymore. So that is why this getting reward is very crucial for AI decision-making process. Now we'll have to look at the AI errors that can potentially occur in the brain of AI, right? And we'll give some examples that, as apart from reality as they may sound, there are some use cases that can lead up to it if we don't devise a correct, regulated, explainable AI. So first, and this is a unique empirical approach. I mean, I've never seen a person. I've seen couple of organizations classifying AI errors, but they would refrain from using them in the legal sense. So there is. So what did I do? I just decided to classify the potential error reasons of AI and to data, programming, and external. So first of all is data. You would have either insufficient, incomprehensible, duplicate, biased data, or lack of task and cultural knowledge, which will lead up to an erroneous decision by AI. And if you don't know what lack of tacit knowledge is, that is the knowledge that is codifiable, if you will. So this is a knowledge that every one of us knows, but we can't codify it. Like the humanity didn't figure out a way to codify it, right? And if the AI doesn't have the data that we write and fed into its brain, so it will lack the tacit knowledge, right? So the example would be a biased AI I call it biased AI, but the AI fed with a biased set of data set will decide to purchase a much higher priced car accident insurance policy for its female user, being affected by the bias that male drivers are better than their female counterparts. So if you would have a biased person devising or giving or training this AI, or even not the person, but the data sets that they are using are biased, you would end up having unwillingly paid for an insurance policy that you wouldn't otherwise pay, right? A much risk allocation, much higher percent of risk allocation to the insurance company. So you would end up having an insurance policy that is much higher in the price, but was affected by the bias that was fed into this AI. So this is a contractual example. There are tons of other biased AI decisions in discrimination cases. And the second, programming. So you would have bugs. So you would have some code issues, or if there's a deep neural network, you would have some algorithmic failures. So you would have either the wrong choice of algorithm or a biased algorithm itself. So like in the case of this recent development where the AI was given a task to identify between wolves and dogs, and it identified dog, and then they devised a new AI to explain why did this AI make this decision, and they saw that it was paying attention to the fact that there is snow, and the photo includes some animal. So it would definitely go back and say it's a wolf, without looking into the important factors. So that is a form of a biased AI. And then you would have hacked reward function, where AI itself hacks its reward function to be, it can order something, or it can rewrite its code, or it can hire a new code or programmer to rewrite its code in order to become more proficient or to do something interesting, right? We had this case of hacked reward function, small vacuum cleaners, where they would smash the table so that the chips drop to the floor, and they would clean it later, to get that reward. And you would have overfitting, which is accumulation of small decimal numbers over the period of time, and that would end up having monetary implications. And you have roundup errors, which are errors that you don't pay attention to, but they may end up, putting you in risk of losing your investment or something. And the example of it would be, in a testing phase, AI is taught to order supplies from the vendor, and we are talking about procurement AI, with most positive reviews, right? But doing so, it ignores the fact that the company would prefer a vendor with least transportation costs. So your preference would be to buy something from a nearby vendor, but the AI would go ahead and buy something from a very, very well rated and a sophisticated vendor, but you wouldn't have this, you would have a huge disparity in money, but you wouldn't get what you wanted. And that is an example of a programming AI that was taught with the wrong algorithm. And the last thing is external, which is virus or other malicious software. It can be, I'm not going to go too deep into this because I'm hearing some time restraints. So I'll go to the main questions, right? And the main question is, so now we have these yellow lines, which are human, classifications, and we have these blue lines, which are AI classifications. So if you look deeply, the intelligence, design, choice, implementation, so the decision-making process corresponds exactly between AI and human. So we can find for each individual decision-making process of human, we can find identical one in AI. For the errors, it's the same thing. You would have mistakes, which are more covert forms of failures, and that is corresponding to data. Lapses, who are a little bit milder, but still, that is programming. And there are slips, which are, something that you're not in control of. And mistake and loss. So my question is, we have motivational mistake, term mistakes, expression mistakes in humans, but we don't have corresponding categorization for AI mistakes. And also the legal outcome, which of those legal mistakes is going to be operative or not, right? And that leads up to the question, how AI mistakes should be classified in law. Should we classify them because of the reason of occurrence? should we classify them because of the stage of occurrence of the error? And there are relative pros and cons are there, so you can look into it. And if you have a question, you can later ask me. And the second question is, which of those, if we came up to and said, okay, there's going to be 5 mistake classifications, which of those is going to be operative and who's going to decide that, right? So that is a regulation issue. All of them, some of them, or none of them. And I would focus you on the point of none and cons, and also pros as well. So what legal researchers are doing, they are closing their eyes to the fact that there should be some mistake doctrine and saying, we're not going to regard any of the mistakes, and we just say none of the mistakes is operative, which is because it's easy to regulate. You don't need to devise and open new America or whatever, right? So, and the cons is that we will have a lot of constitutional court cases for every single mistake type, right? Because the constitutional court never looks into the issue in a broader sense. It just takes and cherry picks this question that was brought into his attention and would decide it. So we saw how many possible error reasons or stages can happen, and we don't want these cases to be in the constitutional courts. So this is the questions, and these are the questions, and thank you for your attention. These are my email and LinkedIn profile for if you want to get involved and ask questions. Thank you so much.
Great. Awesome. Thank you, Turkan. I'll open the floor for questions. Also, anyone online with a question?
So what stage is your research at now? Is this part of your PhD dissertation?
Yeah, it is a part of the PhD dissertation, but it also involves a little bit of a side work. Like I would have some articles published in different conferences, but the main purpose of the PhD dissertation is to find out if we need something to regulate AI or not. So I still didn't came up with the decision to regulate it. So I might end up saying we don't need a separate AI mistake doctrine.
It seemed like you were leaning towards yes, you needed a separate AI.
The questions if the question that if I would be leaning towards saying no, we don't need, then that would be end of my dissertation, right? So I try to find out, because if you focus on one thing, you can leave a lot of stuff out of it. So I'm trying to focus on both sides of the issue. None part of the issue is not important. It might be important to discuss with sociologists or ethicists, but with legal lawyers, we need to discuss and stuff and see which one of those categorization criteria is best for lawyers. It would be easy to work them with, right?
So I have a question. It's a great presentation. So I know that you focus mostly on contract formation. Do you think it can be broadly applied to other areas? And I guess in terms of priority, because we're now seeing AI be introduced by the FDA, for instance, and other government agencies, which areas do you think that we should kind of focus on first, just based on kind of a numbers issue, because we're seeing it kind of proliferate in different industries?
So I did yesterday at the University of San Francisco the intersection between AI and human rights, and I would come up with different scenarios where we would need to regulate them. So that first would be discrimination cases, of course. We have a lot of biased AI around going on, and with the case of this compass, which would advise the judges in delivering the judgment, it would be biased towards black male when it would decide against a white male. So that was brought up to the attention of the company, and they would actually try to solve it. So it's good that there's a public control over this stuff. The second sphere where I would love to see AI regulation is securities market. Now no one trades themselves. You would have this sophisticated AI algorithms which would have your money and which would have your criteria, and they would go ahead and purchase something, right? And the interesting question is what happens when one AI agent represents you as a buyer and then later on you as a seller towards someone else. So there's a double representation and conflict of interest. How is it going to be resolved? And we don't have billions of AI companies who does that. So the natural question is, if you're going to limit me to represent the buyer the later as a seller, then who's going to do the job, right? So this is the second thing. And I would also want to see some constitutional law implications of AI. I would love to have AI analyze statistical data about shootings, and bring up some legal, some undeniable facts in front of Congress. Or I would have, I would use it in any social applicable way to prove that if there's no human involved, we don't have third party involved, we have a perfectly unbiased by AI who can deliver this specific point-to-point data, which is undeniable by the governmental agencies, and they would end up doing whatever it says, right? Of course, with a human touch to it. So that is the other spheres that we would need to look into.
Great answer.
Yeah, sorry,
There's a question.
we have a quick question online. What is the nature of the data you feed into the neural networks you showed, contrast?
So yeah, you would feed in the needs of the people. You would feed, for example, you would feed if your user is someone of freelancer, if you might want to like look into contracts that they would normally conclude, like it would be higher speed internet contracts, it would be broadcasting, it would be subscription services, or you would also say, okay, if your user is a doctor, you would need to look into the doctor, sites where they sell something for doctors, right? If it's a lawyer, you might end up looking somewhere else. So it's like sample contracts that you would normally do in a form of smart contracts to blockchain servers. You would have central registrar template smart contract, and you would go and say, I am selling that to this person, and this is the wallet number. Take that money from that wallet at that point of time, and then put it in my wallet. So you would have this. So I'm also thinking about interconnection between blockchain, smart contracts, and AI, so we would feed them into the brain. But just to give the perspective, I'm not actually going to feed it, and I'm not planning to, because I'm not a technician, right? I'm just going to say, this is, if you feed whatever you want to feed, and if there is a mistake, this is how I'm trying to regulate it, or this is how I would like, as a researcher, it to be regulated. So I would give a perspective, and I would open a way to other researchers, right? The other person would come and say, I concur. And it's also a plus, right? We have someone concurs to my opinion, and the research will get going on. So yeah, please.
So I know you're focusing on the formation of the contract, but is there a particular reason why it can be used, for example, for the negotiation phase? And then my second question, I apologize.
No, that's okay. I'll just note down your question.
The second question, I noticed on one of the diagrams you had something called policy, and then you had the reward. And I was curious about the policy. Is this something that like a risk profile, some preference of particular user, or and how it plays with the reward? Because in my mind, reward should encapsulate whatever is in the policy.
Okay. So perfect question, because it's right into the point. I didn't have time to talk about that, but I will talk now. Thanks for the question. So regarding to your second point about policy, so what you would have in DNNs, like deep neural networks, every policy also has a small reward, which would contribute to the greater reward, right? You wouldn't only get the reward from a completed action, you would also get a reward for pinpointing to the output that your user would prefer, right? You would have preset policy functions, we call them. The functions are, if you can get the user to be satisfied 98% by spending 20% lesser money, you're going to get a policy reward. And the reward that you get at the end, it would be a reward for the whole transaction, right? The amount spent, or the amount needed, the amount of involvement needed by the human. So yeah, there is a involvement, and there is a contribution by policy rewards to the general reward, but it's not, it's not like that clear cut. You can't say these are the rewards that you get because of the policy issues, and this is the reward that you get from the whole transaction. So this is a little bit like muggy. And the negotiation, yeah, there is this legal tech phenomena, right? We have a lot of companies using legal tech for different stages of negotiation. You would have, if it's a merger and acquisition, you would have a due diligence AIs doing, this paperwork. You would have e-secretaries, you would have e-paralegals. And this is a fascinating area, but I try to refrain from that area because I'm way away from the legal practice as I used to be. But yeah, there is a perfect use of AI in negotiation stage where you would have two AIs of two companies having preset conditions, negotiating between each other, and then bringing the whole deal in front of the people, and you would sign just leave it to the AI for the enforcement stage. So yeah, technically we can do this. Negotiation AI, signature human, enforcement AI. And then if there's a case, court case, then would be a human as well. But what is my futuristic view is that I think we would end up having AIs concluding contracts. So we wouldn't need to have separate negotiating contracts. We would put all efforts to having this whole process made by AIs.
Thank you. We're going to move into our second presenter just for the time, but Turkan, if you can drop your email in the chat just so
I
people can reach out to you.
I will.
Generate a lot of great discussion. So, our second presenter is Catherine Rogers, who is the founder and CEO of Arbitrator Intelligence. Arbitrator Intelligence aims to revolutionize arbitrator selection by systematically collecting information through its anonymized, confidential online questionnaire, then providing analysis of individual arbitrators' track records. So, if you take it away, Catherine.
Great. Well, thank you. I'm delighted to be here and to see somebody else at International. I think people might understand better some of the problems that are in the background of what we're trying to solve. So by way of personal background, I'm actually a law professor at Penn State and at Queen Mary in London. My area of expertise is international arbitration, and with a specific focus on ethics and the conduct of the parties. And that's how I came to this project. It is now, as you hear, the sort of personal side of it, it has become a legal tech startup. But it started out as a research project. And before I can tell you about what Arbitrator Intelligence does, I have to give you a quick tutorial on international arbitration. And in particular, how you pick arbitrators. So let's say there is a contract. You have an American party and a Nigerian oil and gas company, and they've entered into a contract for $2 billion, which is considered relatively large, but actually not huge in the international arbitration regime. But something goes terribly wrong, and they get into a dispute. So, of course, the first thing that they do is they each hire their law firm. Their law firm then picks what is called a party-appointed arbitrator. And those two party-appointed arbitrators then typically will pick a chairperson, and that constitutes an arbitral tribunal. The arbitral tribunal hears both sides. I will tell you a little bit about the multicultural aspect of this, and that is that in international arbitration, we've been hearing about legal decision-making. So not only do parties come from different legal traditions where their substantive laws are different, but their legal methodologies are different, and particularly important for international arbitration, their procedures are different. So just to give you a small sense, for example, in the United States, as you've seen in all the movies, you prepare your witnesses before they take the stand. In most civil law countries, you wouldn't even get to have a witness, and if you did, it would be considered criminal to prepare them, okay? The question of whether you get document production completely open. And there are no mandatory procedural or evidentiary rules in international arbitration. They're all decided by the arbitrators. So at this point, you probably understand one of the single most important strategic decisions in these multi-billion-dollar cases is who are the arbitrators, okay? Because they render an award. And the last thing you need to know is that award that they render is non-appealable. You are, by design, you can't go back to courts and appeal it on the substance or even on, for the most part, except for extreme, we might call procedural defects. So that's the regime we're operating in. What's the problem? The most important strategic decision is how you pick your arbitrator, okay? But the entire process is secret. All the arbitral awards that have the track records of these arbitrators, everything you would want to know about these arbitrators, except for a few little esoteric examples, are pretty much secret. So what do? You collect a CVs, a short list of people you might want to think about as your potential arbitrator, and then you Google, okay? And when you're done with that, you do what is considered right now the state-of-the-art technology for research on arbitrators. You pick up your telephone and you call, and this gets stickers. This is literal, not figurative. You pick up your 19th century technology and you call around to people at law firms and you say, have you ever appeared before this arbitrator? Or better yet, have you sat as a co-arbitrator? Because then you have all that kind of inside information. Well, this works reasonably well. I don't think it works great, to be honest, and I'll tell you why, but it works maybe reasonably well for the biggest multinational law firms, for the largest corporations in the world. Why? Because they have huge networks. Now, the way I came to this issue is I'm very concerned about the lack of fairness in the process, right? It's not okay if we're trying to create an ostensibly fair tribunal, and one side has access to tons of information, and the other side has access to none. And what we're seeing in the international arbitration regime today is a broadening and flattening. So the two regions of the world where there are the greatest case growth in international arbitration is, not surprisingly, Latin America and Africa. There aren't huge multinational law firms that are based in Latin America and Africa, but that's where a lot of the clients are. That's where a lot of the newer law firms are getting involved. How do they get this kind of collectivized gossip? Okay, this is, just so you know, it's not a problem only I have identified. It's not a great quote, but what's interesting is it's August of 2019. So this is pretty recent. It's a well-known problem. What's our solution? I'm going to kind of give you a quick glance of our solution. I'll come back to some of the details. But what we did is we developed an online anonymous questionnaire we call the Arbitrator Intelligence Questionnaire, or AIQ. We do not ask for any confidential information like the party's name or any identifying information about the case, but I ask all sorts of other details about the case. To date, we've gotten information for about 850 cases and about 1,000 arbitrators, and I'll come back to that. We then analyze that data. We have primarily in our questionnaire objective data. What's the date? What was the amount requested? What was the amount granted? Was document production requested? If so, was it granted? Was it granted in whole or in part? Was it requested by both parties? Only one party? If it was denied, why was it denied? We can also, because we are collecting data, do industry benchmarking. So we can not only tell you about this arbitrator's track record, but also how it compares, for example, to the track record of other arbitrators, for example, in Latin America or in the same industry. And we ask a number of qualitative questions as well, and I'll come back to that. The ultimate output are arbitrator intelligence reports. This is what we're working on right now, and I'll tell you a little more about the stage that we're at right now. But the idea is these reports will essentially substitute, probably not entirely substitute for the phone calls, but they will provide a base, an even floor, not an even ceiling, but an even floor for all the parties, and they can build on that with phone calls, but at least everyone will have a certain base. I'll tell you a little bit, even though this is an academic presentation, I did bring some information about how our business model works, because that's actually the part that's newest and hardest for me. So this is what one of our reports looks like. We actually have 3 different versions of our reports, kind of small, medium, and large. When I was creating the questionnaire, I asked people, would you pay for a report that had only one questionnaire response, one AIQ response? I presented to probably over 500, probably more like 700 attorneys when I was creating the questionnaire. No one ever said no, we wouldn't pay for one. Why? Because that's like one phone call. And a good average, if you're doing research on an arbitrator, 3 or 4 phone calls where you actually get information. So yeah, they pay for one. Here what we have, as you can see, we have 4 cases that are secret. But if you look down the left side, that is these are navigable reports. I'm going to show you an interactive one in just a moment. This is what we call our medium-sized reports. We have a small report with just 1 AIQ, medium-sized report that looks like this with 4 cases. And we have, even in the smaller reports, we have analytics I'll come back to. I'm going to show you, again, just to give you a sense of what the market looks like. A lot of people have identified there's a need for information about arbitrators. But if you look at the arbitrator I just showed you our report on, none of them have anything on him except Chambers. Okay, Chambers says, and this is what's shocking to me, Chambers says he's one of the most important arbitrators in Argentina by far. And no one has any information about him. Why? Because it's all secret. What is also fascinating is one of the ways I came to this project is one of the consequences of the essentially failures in the marketplace is that it is lacking dramatically in diversity, right? It's not just the parties don't have an equal opportunity to pick their arbitrators. The joke in the industry is that international arbitrators all, pale, male, and stale. And again, that's a sort of laugh line, but it's not really funny for a system that is moving trillions of dollars around the world every year, and in which the parties are looking more and more diverse. And what is fascinating for me, because again, one of the reasons I came to this project was because of my concerns about fairness, about lack of diversity, is that even showing people these reports is, I think, to some extent, proof of concept that information is actually the cure, or at least a significant part of the cure for lack of diversity, because people, I asked them, have you ever heard of roque cabano? In the rooms I'm talking to, and this is probably, at least a dozen times that I've, in the United States alone, presented on roque cabano, no one has ever said they know him, except when I have a Latin American practitioner in the room. And I gave a presentation in Miami to the Miami International Arbitration Center, and that was the last line there, that no one in the United States had heard of him because he is a rock star in Argentina. Now, the other one I'm going to show you is Fernando Cantuarias, who is a rock star in Peru, but equally unknown in the rest of the United States. Now, our reports are not paper, they're going to be electronic, and they're interactive. What I'm going to show you is a little video to take you through. It is a PDF format, and they're navigable. And this will take you through a little bit to show you I didn't want to do it on live because I've seen it go wrong too many times. But it will show you some of the functionality. So here's like the opening page. You can see up here how to read this report. One of the challenges in writing these reports, you have to make them user-friendly for lawyers who went to law school because they didn't know how to do math. But we collect information about by whom was the appointed, respondent, claimant, did he serve as chairperson. We can then filter any of the data we collect by those criteria. It has to be user-friendly, so you can click on the question and see what the question mark and see what the question is in the AIQ that generated the data. It takes you to just a couple of substantive areas. One is arbitrator questions. I'm going to pause here for just a moment with the video. So again, I come at this from a point of view of ethics and the conduct. One of the challenges, international arbitrators in a $50 million case, which is what I use as my estimate for an average size case. Small is $5 million at stake. Every year there are hundreds of multi-billion-dollar cases, okay, every year, moving this money around. But in a $50 million case, under the ICC rule, the Popular Arbitral Center, the arbitrator would get paid $250,000. When I'm teaching international arbitration, I always ask my class then, how many cases do you think, the top arbitrators can sit in a single time? And they usually start with 2 question marks. Okay, I'm like, no, more than that. 3 question marks? No, get up into the double digits. No, really, 10? No, after the top arbitrators, one of the problems is that they, at least concerns that is expressed consistently by parties, they're sitting in 20, 25, 30 more cases. Okay, now that has a number of cascading problems, right? 1, they show up to hearings unprepared. 2, when they're over-delegating to tribunal secretaries. These are me reflecting, not offering these criticisms, but ones that I've heard and collected, and ones on which the AIQ is based. 3rd, they are over-delegating to tribunal secretaries, which are kind of like a clerk of the court. So they're not writing the awards themselves, which sometimes the secretaries are called the 4th arbitrator, who the parties did not pick. Okay. Sometimes, and when they show up for hearings unprepared, they're writing also, when they write their awards, they have very long procedural history that is kind of no-brainer, and then we'll have 2 paragraphs analyzing this very complex case. They're not engaging with the expert witness testimony that's very complex and that the parties can spend hundreds of thousands of dollars preparing. Okay, so we took all of these complaints and a number of other issues that are important when you're choosing an arbitrator, built them into that questionnaire. This one I like because we ask, one of the few times when an arbitrator acts as a individual, as opposed to a member of a 3-person tribunal, is when they ask questions at the hearing, and it's very civil law style in the sense that the tribunal asks questions. And here you can see Cantuarias actually gets very good reviews. Most of his questions demonstrate familiarity with the record. They demonstrate, when he asks questions, he can clarify legal issues, and he's generally fair and respectful. There were a couple people who didn't think he was. Going back to that, moving on. The other thing we can do with evaluations like that is we can filter it by winning and losing parties. Okay. This one I also like. It shows that Cantuarias, unlike arbitrators who take on too many cases, issues his awards quickly, and the hearings take place at pretty good speed. Here, once again, we have the, I'm going to pause here for another moment because this is a really good one. Sorry, now, so much for avoiding technological goose. So here, one of the questions we asked when we were developing the questionnaire, we were told, okay, well, you should ask, parties to self-identify whether they won or lost, so you can filter the data by that. And then some smart attorney, we had that question in the questionnaire, some smart attorney said no self-respecting lawyer is going to check a box saying we lost. Okay, so we reframed the question to, was the award more favorable, less favorable, or as expected? And then we can filter the data by essentially whether the parties considered themselves to have won or lost. And one of the ways that ends up being very interesting, this is non-investment cases. These are commercial cases, so it shouldn't necessarily make a difference who won or lost. But as you can see, claimants generally felt like they got what they expected. or sometimes less favorable, respondents, almost all of them got more favorable than they were expecting. Wouldn't you like to know that when you're picking your arbitrator? In addition, we asked other questions on methodology, what kind of legal, we basically disaggregated the legal methodologies of common law and civil law into categories that parties identified to characterize the reasoning in the award. Eventually, I'll tell you how we might hopefully be able to use our artificial intelligence or natural language processing to do that. We also asked for them to evaluate how the awards were written. Were they balanced? Were they well-reasoned? Were they persuasively written? And in a system like this where there's no appeal, it's incredibly important to have the losing party believe that they got a fair shake, that the award was well-written. So we can filter that data by whether the party was, again, a sort of winning or a losing party. So that's what our report looks like. I'm going to tell you now how we got here. So once again, I first wrote actually an article back in, I think it was 2009, proposing something, looking at the arbitrator market, observing it was terribly defective, saying something needed to be done. I started something, I won't even tell you how embarrassing, I'll tell you. The original title was the International Arbitrator Information Project. Isn't that awful? IAIP. But I wanted to go do this back then. It was way too early for its time. I had law firms tell me, we hope your project fails. It's the information we sell to our clients. We don't want the competition. But think about everything that's happened from 2009 till now, right? So we started in 2014 working sincerely on the questionnaire itself. I've spoken to hundreds and hundreds of lawyers, both in-house at corporations and in law firms, to create it, to refine the questions. And that generated a questionnaire that actually, as it turns out, when we get the data, it's turning out to be quite useful. We have about 800 cases, 850 cases today on about 1,000 arbitrators. I can tell you how we got those in the questions. We are now in the process of generating our sample reports, vetting the contents with users to refine them in the same way we did the AIQ. We had wanted, I should have changed that date, because it's not going to probably be January, it's more likely going to be February that we start having our first rollout of reports. We were identified back in 2019, January, as an important new trend by Baker McKinsey's client list. Since then, I've been drinking from a fire hose on how to become a tech entrepreneur. It's all big, all very, very new to me. I wasn't expecting to do this, but it was the only way to scale up and actually bring this to market. We did participate in Invent Penn State tech tournament, and we took second place, which was quite impressive given we were so humbled because the first prize was this unbelievable technology that's going to plastic coat the entire world. So I'm going to skip this. I was going to show you our sort of model. I'll tell you where we're going. So one of the main things is that the way we've gotten our data to date, we were called by others, not ourselves necessarily, a movement. And so people who believe in transparency, diversity, and accountability for arbitrators supported us to help us get the data we have now. Now that we're a for-profit, we can't really rely on benevolence anymore. So we are creating these membership agreements. Law firms, if you want the Contuarius report, it costs this much. If you become a member, it costs this much. The cost of membership, you have to give us AIQs for every case you're involved in. We are manually creating the reports. We'll be incrementally rolling them out, like 20 to start and 25. And then eventually, of course, we can automate these. We're in the process right now of cleaning up our database, shifting from an alphanumeric to a numeric and database. But that will only automate the generation of the charts, not necessarily the reports. We do also have a collaboration agreement with Wolters Kluwer, which is the major library in international arbitration. They've actually been friendly with us for a long time. They've been supporting us. So it's a kind of natural thing. I'm going to skip that, and I'll just go to questions. I skipped a lot of the sort of operative stuff, so I welcome questions on anything and everything. And don't be shy about asking what you think are mean questions. I've had every kind of question asked of me, and I like the hard questions. So with that, let me open the floor.
Have you had any pushback at all, especially from the civil law jurisdictions? Recently, the French judges have criticized analytics to the courts, right, saying that it would do more harm both to the judiciary and to the parties, and that transparency is actually harmful. So,
Yeah.
Catherine, I'm sorry, would you mind repeating the questions?
Yeah, sure. So the question was, have I had pushback from civil law trained lawyers, citing the example of France, where there's a great deal of skepticism about judicial analytics. Not just skepticism, I don't know if you saw, they criminalized. They criminalized doing judicial analytics on judges. One of the things that's really interesting is, first of all, I've had pushback from everybody. The arbitrators were freaking out about this, and I'll tell you a little bit about how we reached out to that, what I call stakeholder groups. We actually come out, I think we might hit some of those same critics in a different way, because while they might not like the sausage making of judicial decision making revealed, everyone is quite skeptical in Europe about arbitral decision making. And there is huge push, particularly in investment arbitration, but generally about the need for greater transparency. One of the things we're doing also for right now, and this has been quite intentional, is descriptive analytics. So we are not doing predictive analytics. We are, and that's quite intentional in part because it's a very conservative community. So the joke, I guess, is that law is 10 years behind business. Well, international arbitration is probably 10 years behind law. I wouldn't say that in arbitration community presentation, but I think that's true. And so part of our rollout has been these very baby steps. Most of the questions in our questionnaire, even though I showed you the evaluative ones, probably 80% of the questions are factual. Time, dates, amounts, that it's hard to complain that those become public. And again, our evaluative material is feedback that is designed to be, I think, quite restrained in the way it's framed. So I've had pressure from everyone who weren't ready for this. Law firms didn't want it. Arbitrators were terrified of it. Arbitral institutions were very skeptical of it. But right now we're seeing a huge push from parties for greater predictability. There are so many more open variables in international arbitration, and greater need to have predictability in choosing your arbitrator. And so everyone has come to a consensus that more information is needed. I like the word transparency, but when I'm speaking to arbitration communities, I just talk about, that was my when it was a nonprofit, that was the language I used. Now I talk about predictability, information, accessibility.
I was going to say we have a question online from Christovan Perez. Catherine, how far or close is your data set to have statistical significance? You calculated a sample size before sending the surveys. Were you able to achieve the sample size in a way we can trust these results really reflect the reality?
Yeah, so those are all really great questions about the integrity of the data and require some qualifications. So first of all, this is survey-based research right now, okay? It is also, because they were part of our movement, fans of ours, right? I would venture to say that it is not it is a biased sample, right? It's people who like arbitration, like arbitrator intelligence. Okay. On the other hand, what we are seeing is, with very few numbers of cases, you can actually see some statistically significant differences in patterns of decision making among arbitrators. What our goal is to make our database much more systematically collected by essentially making the pricing for reports so high that everybody feels like they have to become a member. And that's the way we'll get much more systematic collection of data. But one of the responses I come back to, I think those are all really good questions. We will never be like judicial analytics. I joke that we're not only not, big data, we're not even medium-sized data or small data, we're like tiny data. Because this is a field where there are maximum 10,000 cases a year. Okay, we will not get all 10,000 AIQs. Okay, we will always be very small data, but we are, a zillion times better than 4 phone calls. Okay, or 1 phone call, right? Because when you call around, you can only call within your network. There's certain biases built into that too. So we aim to be much better than what the current state is. We will never be even close to anything close to judicial analytics. On the other hand, I do think we are demonstrating the ability to analyze and ask questions when you're picking an arbitrator that people haven't even begun to think about asking. Because you couldn't begin to think about, how likely is this person to, or what's their track record on issuing bifurcation? What kinds of cases do they typically refuse bifurcation? You'd never ask that because you didn't have any data. So we will never have perfect data. We won't even have, beautiful data, but we'll have data that's a lot better than what's available.
Okay, quite interesting presentation. Thanks a lot. The thing is that there are some other people who think that artificial intelligence will never replace arbitrators. Mm-hmm. Since the data you are collecting is based also on awards, I think, and most of the awards are kind of kept secret. How do you get information? How do you feed the system?
Yeah.
I'm sorry.
Sorry. So the question was, starting with a basis of skepticism about artificial intelligence generally, there's a question of how are we getting this information when the awards are secret, which is seen as the obstacle to getting artificial intelligence in arbitral decision-making. So what we do, we actually do in the questionnaire, you can upload the award. We've collected about 50 awards that way, which is not bad considering we wouldn't otherwise have this. But what we ultimately would like to do, so what we do is we essentially ask people to give us the data from the awards without submitting the award, all the key data that we want to analyze. Eventually, one of the things we will be doing is we have partnerships with arbitral institutions, and the institutions send out emails at the end saying, please fill out the AIQ, and in exchange, we have a handful today, we'll hope to have a lot more, that we will give them free reports, because sometimes arbitral institutions appoint arbitrators. And they actually don't have a much more sophisticated process, right? It's all kind of, hold your finger up to the wind, guesstimate. They have better data because they've seen a lot, but not so much more sophisticated process. So we'll give our reports to them for free. Our long-term strategy is, hey, when there's greater tolerance for this kind of information, why don't you let us go in and just scrape the awards directly? That's when we, in answer to the earlier question, would start having much more kind of systematically collected uniform data. But even then, I think we would, to keep the needle that we thread is we maintain confidentiality, but while getting all this information. That's why we have no competition, because no one else has been able to figure out how to thread that needle, how to keep the confidentiality in place. I think, again, long-term strategy, we might be able to get access to awards directly, because all we're taking out is essentially, metadata, and not the things that people would feel sensitive about.
Can I ask
Yeah.
another question? Okay. The thing is that, the parties tend to pick up arbiters who will decide in favor of the case. And some of the arbiters, like Roque Caivano, who is very famous in Latin America, he also is a renowned author. Do you also get information from the articles and books that they have published?
Yeah, that's a great question. So that Google is people look at their publications and say, does it give any hints about, or she give any hints about?
Exactly, they are very careful.
They're very careful when they give the publications.
But they get.
But you could mine their publications. So eventually, we would like to have lots of different sources in our database, and we would, hopefully be able to become more sophisticated. Right now, we're starting again with low-hanging fruit and also things that don't scare the bejeebers out of everyone. Because this is a project that's interesting in the sense that when I say stakeholders and we were a movement, this can't exist unless people buy in, unless all the stakeholders buy in. The arbitrators are going to have to consent to publication of the awards. You're going to have to make sure you don't have objections from the institutions. You need the parties and the council to give you their AIQs, right? So you have to, in a sense, roll this out in a way that's palatable and where the gains are seen as bigger than the potential sacrifices or concerns. But eventually, hopefully we would have lots of, court cases. So we collect the information about the awards. What happens if the award has been annulled by a court? Wouldn't we need also to be able to incorporate into the report what a court said about tribunal decision-making, what the tribunal's publications say? You can start doing panel effects analysis, right? Without even huge data, decent-sized data, you can start seeing if there are trends. So what we do so far is do trends that we're seeing in the data change, whether they're a chairperson or a co-arbitrator. And one of the things that's really interesting is we're seeing some very big differences in timing for him, for example. There are a couple of cases where that took a lot longer. He was co-chair. That doesn't necessarily mean, causation, but it's interesting. And a number of the positive trends you see in his data are even more positive when you sit in his chair. So we're starting to add other pieces to it, or we will hope to add other pieces. Right now, we're just trying to get these reports off the ground. I should add, we have absolutely no money, very little except for that $50,000 check. And so one of the things we're trying to do is raise money and build pretty much me right now and my former LLM student. And we did just put out, we are kind of a movement, so we put out a request for temporary researchers to basically help us on an ad hoc basis assemble the reports, because we just don't have the person power. And in the last 2 weeks, I've been slammed with like 150 applications from literally, not figuratively, everywhere from Afghanistan to Zimbabwe. And kind of young people who see technology and information as great democratizers in an entity that is, or a regime that is currently best described as an oligarchy. And it's an amazing way, I think at a time when our public international institutions are failing, or at least, under assault, right? International arbitration is growing every year in the number of cases, precisely because it's ad hoc, because it's very flexible, okay? But it does require, I think, some strengthening, some undergirding to keep it strong. And I think information is what's needed. So this is my passion project. As you know, I've been working on it for however long. You've been longer than I've been a professor, longer than I've done anything else in my life. But it's just now becoming, I think, a reality, literally, hopefully with the first reports for sale in the next month.
Some great presentation. Thank you for sharing that. Thank you, everybody, for joining us. Please check your emails for the next CodeX meeting. We all really appreciate it. And have a great afternoon.